goes immediately to Lawrence Gormley, University of Groningen, in the Netherlands. You have the floor, Lawrence.
Thank you very much indeed, Mauro. Ladies and gentlemen, it's a great pleasure to be back in Turin. I have to confess that the last time I was here, I was more concerned with the culinary aspects of Piemonte and some strictly empirical research at Gaia, which resulted in some very good truffles for my dog. But fortunately, I've got other things on my mind today, and I'm going to talk to you about something to do with European technocracy and possibly legal culture, although I think that legal culture is, like all culture, perhaps something which escapes the minds of all except those who are involved in it. European technocracy, I suppose, is something which has really developed, perhaps without necessarily being intended to develop in the way it has. Before I took up my chair in Groningen 24 years ago, I worked at the European Commission, and I had occasion while I was there, having, of course, been a victim of the recruitment system myself, having gone through a concours, also to be on the recruitment panel for selection of lawyers. And it's very interesting, if you've actually sat on both sides of the fence there, to see what sort of people actually come to the European institutions. But before I deal with that, I should perhaps recall that the real conception of the European Commission was as a steerer, a motivator, a guide, a supervisor, guide, philosopher, and friend, possibly, to put it in terms of Glanville Williams's famous introduction for for law students and legal studies. It wasn't actually conceived as the sort of body it's become. To look at how the Commission was originally envisaged, you have to go back to things like the Spark Report, and you see the sort of institutions which were about to be created. Gosh, that's early exit. Yeah, it's about the record, I think. And if you do that, you'll find that the Commission was very much seen as the motor of integration. And that role it still has to a great extent, although, of course, it is possible now for member states to come with their own initiatives. But it was still seen as a really a conceptual body, a much more cerebral body than it has become, where now, of course, it's a complete political hothouse. Also, the sort of things that one is expecting of the Commission have really changed. It's not merely coming up with new initiatives, new ideas, identifying problems in the construction of the internal market, in the development of European integration, and making appropriate proposals for them. Well, that's still a very important part of the Commission's work. It's actually running so many things. And therefore, the European technocrat, if you like, that you're now getting is someone completely different from the sort of person you had in the days when I was at the Commission and the days before that time, when you were really looking for people with ideas and concepts and people who could make things work. But nowadays, you're basically looking for managers, project managers, different types of skills. I found when I was recruited, for example, the Commission had suddenly taken to its head that it wanted lawyers who were good national lawyers on the ground that they could teach them European law when they got there. This resulted in an intake where certainly of the English lawyers who started with me, I think there are only 3 remaining. And I think I was the last to leave after 7 years. Most.
Too many?
Sorry?
You mean too many?
No, there were. We had quite a lot of people, but people who basically found it just unattractive barristers who find they weren't able to stand up in court, people whose spouses didn't settle, and for many reasons. But it was a very strange form of recruitment. I think that policy has now changed, and people want people who are recruited with European legal skills and understanding of European legal culture, if I can dare put that forward, and management abilities and skills. And sometimes, when I was on selection committees, we would actually get people who'd come in, you'd bowl them a question, basically asking them to come up and talk to me about the case law and say free movement of workers. And they'd sit there and just answer the question solely on the basis of national law, without even having thought that there might be a European angle to this. Now, if you're applying for a job at the European Commission and you don't understand that European law actually has something to say about an issue, then you're in the wrong place. You also get some people coming up who are going to be absolutely perfect national lawyers working a little in a back room, dealing with technicalities, but have absolutely no vision. One needs, certainly in the European civil service, a good detailed understanding of a dossier, but also an understanding of where your particular bit of the jigsaw fits in the general picture. And I noticed that some of my former colleagues very much lacked any sense of that second element, that people ended up being so absorbed in such detail in a dossier that where does this fit in and what are we actually doing, that question seemed to go sometimes over their heads. So the sort of European technocrats you're now getting, as I say, are rather different from those. I mean, I'm quite convinced that people like me would certainly fail a concours nowadays, tested on management skills and sort of funny horizontal reasoning and all sorts of stuff, and we'd scratch our heads and say, what's this? But there we are. Times change, and perhaps given that the Commission's tasks have now changed so much, perhaps it is appropriate that one needs other people. But one still needs people who have a sense of vision. Don't have to be uncritical admirers of the European institutions. I mean, the institutions aren't simply asking for yes women and yes men, but one should have an understanding of what people are trying to do. One of the things that I recall from my time in the Commission was that it was actually quite astonishing just how much the Commission got done. Because sometimes you'd find that there was more infighting among the different directorates general over the direction that a particular piece of legislation should be taking. Or in, say, some of the early court cases on the environment, where there was literally sort of blood on the streets as people were rolling over, fighting over the direction of a dossier, with the result that you get court cases brought where the court actually end up giving Commission less than the relevant government had actually offered it to settle the case beforehand. A question of too many cooks spoiling the broth. So sometimes you look at the institution, and anyone who's worked there has been there as a consultant or something like that will say to you, you have a view sometimes of people, perhaps an army where not every platoon commander or every brigade commander knows what the overall commander-in-chief wants to achieve and how. And that can be quite disconcerting sometimes. The other thing which happens is that one finds that quite a lot of lawyers in the Commission find the career structure, I'm talking about technocracy now, I'll come on to law in a minute or two, the career structure somewhat unrewarding, particularly when you have an influx of new member states and the people who are being parachuted into senior positions don't actually know what they're talking about. And if you, just thinking without naming names obviously, but if you think of, say, senior members of the legal service who end up not being able to get a head of a team, a director level appointment, because one has to be reserved for someone of this nationality, you end up with a director who knows absolutely nothing, and so ends up being run by their staff. This doesn't make for an attractive working climate, and it's no surprise that you see a number of people at a relatively senior level saying, well, thank you very much, we're going to go and make money in a law firm, which is not good for the legal culture, and not good because so much knowledge goes to waste. So the career aspects of the technocracy are not always those which make it attractive to stay, and unfortunately that means that it is also very difficult to recruit the best lawyers, particularly from the United Kingdom, where salaries in the City of London are extremely high. Even the not unattractive salaries which the European institutions offer are hardly competitive. So sometimes one finds it difficult to get the best people. We don't yet have a culture which you have in the United States, as well, I would be corrected no doubt if I'm wrong, of people, academics and others, going in and out of government and actually bringing in people to do jobs, work on particular projects. And I think that's something which the European technocracy could usefully think about. They do have detached national experts, but some of those are very successful, some perhaps less so. So enough for search recruitment and problems in the technocracy. European lawyers working in the institutions, of course, come from all member states. That means people coming from very different backgrounds, sometimes very different abilities, it unfortunately has to be said, and one has to seek common ground. Now, one of the interesting aspects of the development of European law is that the common ground has often been sought in looking for general principles. The Court of Justice, certainly in the early days, and perhaps even now still, when it was developing principles of European law, spent a lot of time consulting its research and documentation division, actually getting comparative law notes and briefings to establish the principles of European law. Now, the concept of general principles, of course, was something which was only found in relation to non-contractual liability. That was the only place which you found a reference to principles of law common to the member states. But that mention there was a sufficient peg for the court to hang the development of the protection of fundamental rights as an essential element of the European legal order, and to develop that whole case law, leading to the great arguments, of course, with the German Constitutional Court about the protection of fundamental rights. So just one thing there, it's a very short step from saying, well, general principles of liability and damages. We will also bring that into questions of validity and annulment actions. And so the court set the development of fundamental rights protection in motion from a very small seed. So a common core, general principles of law in particular, has had a major role to play. And sometimes one develops principles coming really out of national law. Proportionality was a major German influence, of course, on in the case law of the court. Developed in agriculture, for example, as Francis Snyder well knows, with the questions of testing the extent of EU action in organizing the agricultural markets. Developed also in relation to free movement of goods and other freedoms. But that sort of principle, having been developed originally inspired by elements known to national law, has now come back because one starts to see national judiciary saying, well, if in European law situations we would be applying principle of proportionality in evaluating, say, government action, that's actually a good idea. Why don't we just do it in situations not governed by European law? So you see judges being willing to take principles developed at European level, apply them outside the pure European context to improve the quality of legal protection in the national legal systems. So then, both the court and the commission, of course, were able to take the treaty and mould things out of it. If you think the whole growth of European contract law has come originally from a basis in consumer protection. The growth of environmental law before a specific legal basis was created came from the old provision, the old Article 235 EC, which stated that if the action was necessary for the proper functioning of the common market in those days, and the treaty had not provided a relevant legal basis, then the council could act, etc., etc. So the institutions conceive of European law as being something not static, but dynamic. And the dynamic nature of European law is something already, of course, envisaged in the Spark Report. I was at a British university not so long ago, and somebody who's allegedly a senior lecturer in European law asked me, what's European law about? What's the European Union trying to achieve? And I said, well, have you ever read the Spark Report? He said to me, what's the Spark Report? I nearly fell off my perch. To me, it was inconceivable that someone who was involved in European law would not know what the Spark Report was. It's the founding document, of course, those who aren't European lawyers, on the basis of which the inspiration of the EC Treaty was drafted. One of the things I do see, actually, even among young European lawyers, is that people don't read their literature. People aren't interested in anything more than 5 years old. That's a very big mistake, a fundamental error, which is why I sometimes say, go back and read some of the inspiring early works, and then find out why we are where we are, and also you can get inspiration from the early works for future development of the law. So European law then is dynamic in nature. Now when people are talking about common cause and developing general principles and many projects, one thing it has struck me, I was talking about this in relation to tax law some time ago, but it also strikes me more generally, is that it's important that you should not lose sight of the fundamental freedoms of European law and the general principles of European law itself. So that there's not much point in constructing something which doesn't take account of those important areas. And you hear, people like the tax lawyers jumping up and down and saying every 5 minutes, oh, the European Court understands nothing about tax. And somebody else comes up and says, the European Court understands nothing about this and nothing about that. But the niche lawyers forget that every area of national law, even if it's an area where it's purely national competence, has to take account of the requirements and the fundamental rules of European law. So that the concept of national competence doesn't mean that areas are off limit from the requirements which European law makes on the basis now still of the principle of solidarity and loyal cooperation and the duty to abstain from anything which would jeopardize the proper functioning of European law. The national legal systems and national law is obliged to take account of that. And therefore, national competence is not to be thought of so much in a set of reserved powers, but of powers which are there where, of course, action will be taken at national level. But such action as is taken at national level must respect the fundamental freedoms of the treaty. Not necessarily always a popular message, but it's the message of the Court of Justice nevertheless. It's a message which people would do well to take account of. The next thing I want to perhaps talk about is the need for consistency. In development of legal concepts and legal terminology, we need to ensure that there is consistency. Just think, for example, even consumer law. If you look in different instruments of consumer law and in the case law of the court, you'll find a wide variety of definitions of the consumer, not always the same. And that also brings me to a point which the Court of Justice has stressed in relation to references to preliminary rulings, which is that European law has its own terminology. I've said, obviously, in the early days in particular, European law is drawn on national legal concepts, sometimes coming from one or other member states. Reference to preliminary ruling was drawn actually from, in great extent, from concepts known in Italian law. But we are not in a position at the European level in allowing one legal system to export all its own values and ideas. Thus, for example, in the Omega Spielhallen case, the video games simulating killing of humans, where the Court of Justice upheld a decision by the Oberbürgermeister in Bonn to prohibit the use of this type of video game in entertainment halls. They were very careful. Distribution, yes, and distribution in video sales. The court was very careful to place its view of public policy as here a European concept of human life and the importance and inviolability of human life. It said, yes, of course, the inviolability of human life is recognized in the German constitutional tradition. Fine. Thank you very much. Yes, we note that. But it's also a fundamental principle of European law. So the court, when looking and applying its principles, developing European law, is conscious to situate these principles and decisions within the European context. This is why on the recent views on recent judgment on the migrant worker or non-worker who's after social security benefits in Germany, was decided a few days ago, the court actually founded its judgment firmly on a reading of the Citizenship Directive. It happened to be very useful to say, well, somebody who's not economically active and isn't looking for work doesn't have to be, have the hand fed with money every time they put their hand out. That was very useful for Cameron, in fact. But it may actually make it more difficult for Cameron to renegotiate, so it may not be useful for Cameron. But it very firmly founds its judgments on the treaties on the basis of the case law, and therefore wasn't a surprise. So sometimes if you think the Court of Justice doesn't understand this and that, what the Court of Justice is doing is applying the principles developed in the treaty and under the treaty. And finally, just one observation on the rule of law. We have, of course, a magnificent presentation now from the Commission on the rule of law, which is extremely interesting. But it does seem to me that politicians are now promoting a culture of non-compliance, and at the moment judges do something which the politicians don't like, the politicians say, oh, we're not going to your court anymore. And this is what's happening in Britain where people are saying, well, perhaps we should withdraw from the European Convention on Human Rights. It's also happening in other countries when both in the UK and proposal in the UK and in the Netherlands already, it's become very much more difficult to get access to justice to counteract administrative acts. This will say nothing to you as private lawyers, perhaps, but it's made access to justice very much more difficult. And the one thing I want to say to you is that the moment national authorities start to make it more difficult for litigants to get to court, particularly when attacking public measures, which are often outrageous measures, then as sure as night follows day, you are on the start of a slippery slope to an authoritarian system of government. And that's something we should watch out for. So, ladies and gentlemen, with that, having given you, I hope, some food for thought, I wish you very well in your endeavours, and I hope that in the attention to the detail, no one will lose sight of the bigger picture. Thank you very much.
Thank you very much for this most interesting remarks on the functioning and from within the EU institutions. I guess you're entitled to the same piece of floor the other speakers had yesterday, so if there's any question or comment or remarks.
Deadly silence.
Professor Snyder.
I would like to ask where it's been relatively easy to get access to the courts and get the courts to review government acts. Now one has to pay far more before one can bring a case. There's also been a clear sign being sent from the Ministry of Justice that we've adopted a culture where a decision is taken, you can make an objection to it, the objection will be routinely dismissed, you go to court, and all the judges will nowadays do is look to see if procedures have been followed. So the current culture is against looking at any substantive test of whether something is reasonable, whether a measure is actually sensible, is based on the grounds on which it's alleged to be based. And you see that the government culture is effectively to discourage as much as possible challenges to public acts. And this is very wrong, but it starts off with a slippery slope. One starts with compulsory identification obligations, and one goes down the slippery slope. And in Holland as well, you have people who scream that the European Court of Human Rights and the Court of Justice are, exceeding their authority. Well, actually, the answer is they're not. In the words of Pescator, what the court does is face the institutions, the member states, and others with the legal consequences of what they've signed up to. And this sometimes comes as something which is difficult to understand. If you just think of something not in judicial terms, but in political terms, all this hoo-ha about recalculation of payments to the EU budget, which suddenly the prime ministers are detonated left, right and centre. The ministers of finance knew all this. They all signed up to a re-evaluation, and then they complain when the method which has been agreed produces results which they don't like. I'm sorry, but if you don't want that sort of thing, you shouldn't sign up to it. And at the end of the day, the complaints that, and more Brussels this, more Brussels that, people forget, and the politicians forget, all the essential things have been agreed at political level. And even if sometimes people are outvoted, Nevertheless, everyone's had their say and had their potential for input. And the culture of non-compliance, which you see in certain countries, is really quite disgraceful.
Any other? Yeah, Mr. Goldman.
Thank you for a masterly presentation, which I thought was really fascinating. I want to just mention one thing which I thought was really interesting. You talk about remembering these principles, but you also mentioned, I think it was very interesting, about the need for consistency in the application of these principles at a court level, not just the people who are operating actually as technocrats within the European system, but also at a court level. What do you think can be done to get that consistency that isn't being done in the past?
I think on the one hand, the court itself has to be careful not to sacrifice logical consistency on the altar of political convenience, which you see it having done in a lot of cases in the environment. Balloon waste, of course, springs to mind, but there are also others. I think also one needs to give the national authorities a sense of involvement and a sense of purpose. I'm not pleading for huge national involvement in the extra-national involvement in the decision-making process. I mean, you've got now the parliaments involved with their yellow cards and so on. But I have a feeling sometimes that the national administrations don't actually understand what's going on and what is being negotiated and why. And you meet the greatest resistance with the small local official who has no discretion and doesn't understand. So I think that I think one needs to have a civil service which is more aware of the greater picture and can ensure that the ideas aren't just seen as, you know, some tablets written on high Mount Sinai in Brussels and comes down and rather like the gods in the Gute Mensch von Sichuan ascend on a pink cloud, leaving the world to sort out its problems at the end of the play. I think one needs to involve them more. But that's a question of education and training. I also think that one has to get the politicians to understand that there's not much point in them signing up to something in Brussels only then to go back and to the local popular stage and denounce everything which is being done. Politicians are unwilling to face up to their responsibilities. And particularly, they haven't worked out how to cope with popularism, where people's only claim is we don't want this and we don't want that. If you look at what happens in the Netherlands, Geert Wilders and UKIP exactly the same. Well, what will you do if we leave the European Union? We want to leave the European Union. What will you do if this and that? We want to leave the European Union. They've no ideas. And part of the problem is that there is an understanding gap between what is happening at European level and the ground and the work floor. And I think that needs to be addressed.
Thank you. Ugo?
Now, I have a question also about the thing of the culture of non-compliance, because it seems to me that things are a little bit more nuanced than that. In my own field, for example, which is property law, the jurisprudence and the case law and the culture, the legal culture of European law, made us move steps far away from all sort of social conquest and all sorts of social equality reasoning that was reached in the 70s and through the first part of the 80s with, an exceedingly political interventionism that seems to me is against the very nature of the treaty provisions about property law. So it seems to me that this is a big question. Then also consider the fact of the European Commission getting involved in illegal or extra-legal, let me put it, extra-legal activities such as partnerships with the IMF and the central bank, giving birth to the Troika, which is an institution that appears from nowhere and suddenly becomes a machine of enforcement of austerity policy in Southern European countries and places like that. So all of this seems to me gives some good reasons not to comply. And not compliance sometimes might be called resistance. So I'm wondering, whether your take isn't a little bit romanticizing what a great thing would be, which I agree, to have a European Union or a European technocracy that actually works with a culture of respect.
Well, I'm the last person to claim the Commission always gets it right. In fact, I even brought along the judgment in Microban as a very good example of the Commission failing to get it right by adopting measures which it had no legal right to adopt. These things happen. Look, political developments like arrangements with the IMF and others come out of the economic necessity that people have to talk together and work together. The requirement that the treaties don't affect the systems of property and property ownership in the member states. That member states have come up with this property argument really since the beginning of the communities, and they've always come up with it in a situation where they try to think that this will torpedo any applicability of the principles of European law, and the courts always rejected it. The system of property ownership as such is left unaffected, but the way in which you can apply is not. For example, you only have to look at cases on second homes and access to moorings and residence requirements in relation to property and things like this to see that European law can have an effect on the way in which you organize a particular system. Non-compliance is, it can be called a great civic disobedience, but at the end of the day, the certain countries frankly committed fraud. One country in particular, when they joined the euro, all the other ministers of finance were just waiting for the relevant minister to say, oh, well, of course you know the figures aren't right. But they never did, and because countries have a respect of saying, well, if a politician from one country tells me X, then I'm bound to believe he's telling the truth. You find that people are in problems. If one's going to have some form of European solidarity, then one single member state can't simply expect that it can hold out its hand and say, thank you very much, please rescue us from everything we've done wrong for the past God knows how many years. And if people take to the streets and say, we're protesting about this policy and that policy, well, it's about time they paid their taxes. The culture of I'm not suggesting, the moment the authority says X, you should bow down and worship it. But I am saying that a lot of this culture of resistance is all very well, but the dissatisfaction is wrongly aimed. Dissatisfaction should be aimed at what the national political class has done. There is I entirely agree, a gap between expectation and delivery in terms of that message of what's actually happening in Europe and what Europe is about. And people don't want to see that because they want to blame somebody other than their own political level. Politicians are very bad in accepting the blame, and national politicians are very bad in accepting the blame for having fundamentally been corrupt. And this has led to all sorts of problems in various countries. But it's not much good, targeting your fury at the wrong people. Don't shoot the messenger.
Yeah. Professor Dacaron.
First of all, congratulations for the very nice and presentation. But I just wanted to say that it is very simple or simplified just to say that, okay, countries have to pay and persons have to pay taxes. But in some countries, as like Greece, for example, perhaps you mentioned Greece, I didn't mention it, but it's one of the states that had to be under the state under Troika. Of course, there were people who have evaded taxes, but the persons who have not evaded taxes and who were paying taxes are called upon now to pay even more taxes for those who didn't. So sometimes it's not so easy and so simple to say that you should call upon people and pay taxes. Thank you very much.
No, I accept your argument entirely, but you're actually confirming my point that the criticism they should be directing is against their national politicians and not against the European Union. The criticisms at the wrong target. I wasn't going to mention Greece by name, but I happen to know, because of litigation which is going on elsewhere, that the Greek civil service is still trying to enforce totally unlawful policies, which they've actually acknowledged as being unlawful, by underhand means. And they're not the only ones. There is seems to me to be in many member states, a culture, even amongst the civil service, of deliberate disguising of conduct which is just clearly indefensible. Now, if you or I personally to engage in that sort of conduct, we would very soon find a very heavy burden falling upon us. But it seems to me that the certain member states in particular feel that the moment one is in public office, one can do anything one likes. And it's that sort of culture which strikes me as being at the root of the problem.
Yes, but if I might add 2 words, it's not only the politicians of the state members, of these state members, but also the European Union of not taking care all these years if one member state was committing fraud, if it committed fraud, and just let things arrive after 20 or 30 years and said, oh yes, you did so. So I think from the beginning the control should have been better, and not just to arrive at a certain point and then point out at a certain country or not. Thank you very much.
No, I entirely accept that, but I think I pointed to the problem when I just told the story about the finance ministers. The Court of Auditors screams blue murder. Most of the losses are caused at national level in national spending of European funds. Corruption at the institutional level among the institutions is such small scale. It is really very, very unusual. But yes, enforcement has been an issue. But the trouble is, you see, that politicians aren't willing to downface each other. The Court of Auditors can say this ought to be done, that ought to be done, but at the end of the day, the ball comes back to the political class. And the political class has a lot to answer for.
Thank you. Any other? So for reason time, we are obliged to close this fascinating part of the plenary session. I want just to add that one sentence. This is a tricky game, this naming, blaming, and shaming local politicians, EU politicians. There's no innocence around. There's not enough innocence around on both sides. And most of the times people are squeezed in between without having a clear point of reference, either cultural or political. And this would deserve a longer discussion that we can now. Now the time is come for the reports of committees chairs. Aurelia Colombicciacchi, Anna Di Robiland, and the only guy in the group, Franz Verro. I don't know what's the order, if they agreed about any order. Otherwise, I would call first the ladies and then the gentlemen. No, they use the mobile micro.
Thank you. Well, first of all, I have to say my name is not on the program because I was asked to chair the contract session when the program was already printed. So I'm the brand new chair of the contract group. And we have had a very fruitful, very nice discussion yesterday morning. We have discussed 3 ongoing projects. All 3 of them are nearly to completion. And we have discussed one possible, potential new project. So the 3 ongoing projects are remedies in contract law, remedies in contract law. This project is so advanced that there was no need for further small group sessions, and also none of the 3 editors was present. But I met Paula Gilliker from the University of Bristol at the beginning of September, and she told me that the project is really nearly finished and the book will come out very soon. The second project we discussed, interpretation of commercial contracts, is also very advanced. The book contains 10 national reports. 10 national reports, carefully chosen, with a representation from both older member states, newer member states, southern, northern, Scandinavian member states. Also this book is near to completion. The time frame foresees that the manuscript will be completed in November next year. So the next Common Core meeting will be the final event for the book manuscript being presented. They are writing the comparative remarks at this stage. So all reports they have foreseen have been also actually delivered. And they are writing the comparative remarks, and both the formulation of the cases and the work of the case answers, and now the work at the comparative remarks, evidences the fascinating interplay and weighing of different factors of interpretation, factors of objective interpretation, context, principles of justice, also meta-legal needs for justice, the interest of the parties, of course, the subjective intentions of the parties, and one basic outcome on one basic line of the book is the fundamental difference between common law and continental civil law approaches on the weighing of the factors for interpretation of contracts and commercial contracts in particular. So the book is in good hands, and next December it will be physically in our hands. And the same applies for the book Immoral Contracts in Europe. So this is the fairly thick manuscript. We have received 21 national reports. We had the ambition of covering all 28 EU member states, and we had found country reporters from all 28 member states. However, then for practical reasons of feasibility, the problem is that a couple of these reports will not be ready in time, or perhaps the country reporters will not be able to deliver at all. So we have set the mid-December of this year, so within 5 weeks of time, as a final deadline to deliver the country reports. And because we already have received 21, it's a critical mass, and we will go on with the reports which will be delivered within December of this year. And so we will keep our schedule that the book will be published next year. The work at this book has been a great pleasure for all three editors, Chantal Mack, Zishan Mansour, and myself. And we have really worked with meta-legal formats, and also from the beginning, and also in the discussion of today concerning the other projects, we have stressed how the meta-legal formats can and should be discussed in the books. So I have good news, and also for new projects, a very interesting idea has been proposed yesterday morning, transfer of debt. So the opposite is the transfer of credit, transfer of debt. This is a matter which has not been dealt with in depth within comparative law or harmonization of law projects. And so we will be happy to host a project of this title, with this title for the next years. And the work as a possible questionnaire will begin in the next months, and then next year, hopefully, this project will be officially presented. The balance sheet of the contract discussion has been very positive in total, and I'm very happy to have been the chair. Thank you very much.
Anna Di Robilan for the property group.
I'm Anna Di Robilan, and I'm the chair of the property group. I want to start by thanking Mauro and Ugo for inviting me to chair the property group, and also Saki Bailey, Pepe Mastruzzo, and Michele Spanò for all the wonderful work they've done in organizing these 2 days. So we met yesterday morning, and we talked about the projects that are underway. The Protection of Immovable Property project, which is edited by Peter Sparks and Sonia Martin Santisteban, is approaching completion. It has actually been submitted to Cambridge University Press, and we've already received positive feedback. So that is going very well. There is a project on transfer of immovable property edited by...
Anna, excuse me, one thing you could not know. They already had the green light for publication. There always is a nuance, a detail issue about the title. So it's going to be published this 2015. With
the title?
With the title that has been modified slightly.
Oh, the title has been modified.
Yeah, but the peer review has gone perfectly well.
Yeah, I know that, but not... What is the title?
There are 5 or 6 proposals going back and forth, with Sonia resisting to in having one of them, and Cambridge, which has a very bad taste for titles, by the way, insisting on a different one. But the general issue is protecting
it's coming out, but
property
with a different
movables
title.
in Europe.
Great.
Oh,
So
yeah, they got no idea.
the volume on transfer of immovable property, edited by Andrea Pradi and Luz Martinez Valenzoso, is also approaching completion. They plan on finishing by February. It needs a linguistic revision, and the initial chapters still need to be drafted. Then we have other 2 projects. Security Rights in Immovable Property, edited by Francesca Fiorentini. The questionnaires have been revised recently. We have a full list, close to full list of national participant respondents, and Francesca asked me to mention that we're still looking for people from France. We then have an access, sorry Francesca, yes. As co-editor. Okay, great. And we have an access to the Commons project, edited by Saki Bailey, Filippo Valguarnera, and Ugo Mattei. We discussed the questions yesterday, and again, we're looking for people from France and the UK. So if you have any suggestions, please email us, and that would be great. We devoted the rest of the meeting to discussing future projects. The group has produced in these years an amazing wealth of knowledge, and the question is now what to do, where are we going in the future? So what we discussed is a possible normative vision for the future and projects that would reflect this normative vision. So the question we thought, some of us thought, could serve as the starting point for our conversation is, in the face of rising inequality, how can property contribute to an equitable pre-distribution? What type of property institutions would be required in a society committed to equitable pre-distributive rules of the game? And let me say a little more about this. So, Europe has grown increasingly unequal in the last 30 years, as we all know. Piero Zamballon, in his French political historian, in his recent book, The Society of Equals, has noted that Europe is facing a crisis of equality. A crisis of equality that is a political crisis, a moral crisis, an intellectual crisis. It's a political crisis in that it is a crisis of a discomfort with taxation, with redistribution, with the welfare state in general. It's an intellectual crisis, the crisis of the idea of social equality that was born out of the modern revolutions. And it is a moral crisis, the crisis of the ideals of autonomy, but also reciprocity and community that are the basis of modern democracy. So in political theory, political science, and economic circles, the latest response to the crisis of equality is pre-distribution. New big idea that is, moving from academic circles to advocacy groups and politics. And the idea of pre-distribution, the term was coined by Yale political scientist Jacob Hacker. The idea of pre-distribution is the way the market distributes economic power in the first place, even before the government collects taxes or pays out benefits. So rather than correcting, equalizing unfair market outcomes through tax and transfer, we engineer markets to produce fairer outcomes in the first place. And this, of course, means expanding the role of government significantly, well beyond regulation, well beyond the technical curbing of the worst excesses of the market, towards what political scientists call a people-centered approach. A people-centered approach that seeks to endow everyone, regardless of the circumstances of birth, with what is needed to respond positively and confidently to the uncertainties of the global economy. It's an ambitious ideal. Why do we think this is an idea that has real potential? Well, it's an idea that has real potential because if taken to its logical conclusions, it can really go beyond a competing approach that has so far dominated normative discussions, which is equality of opportunity. Equality of opportunity has two big shortcomings. The first shortcoming is equality of opportunity has very little to say about unequal inequality in end results. Equality of opportunity assumes that once individuals have roughly equal opportunities to compete, to fairly compete in the market, the way the market distributes economic power is something we shouldn't worry about. Equality of opportunity also has another significant limit. It assumes a very narrow notion of self-reliance that denies human vulnerability. The idea is opportunities are equalized once unchosen circumstances are counterbalanced so that only individuals' efforts, talents, ability will determine their outcomes in life. But we all know that effort, talents, ability, and to a certain extent effort are the result of luck, patterns of socialization, and contingent market preferences. The pre-distribution approach has the potential to address both these shortcomings. It takes the question of inequality of end results front and center. It acknowledges that markets are not natural self-regulating mechanisms, that markets rest on rules of the game that are the result of political decisions, and that distorted rules of the game that lead to high levels of concentration of wealth and power hinder growth, hinder innovation, and threaten the very basis of democracy. It also acknowledges that individuals are inherently vulnerable, that there are structural limits to one's ability to lift up, as well as personal limits that individuals are only indirectly responsible for. And it seeks to endow everyone with what is needed, with the resources that are needed to respond confidently to the uncertainties of global economic life and of one personal life. So it's a wide-ranging approach, an approach that targets inequality and vulnerability, and that, of course, requires a complex package of policies that focus on assets, on skills, on democratic decision-making, and on character. Now, assets is where property law comes into play. The pre-distribution approach.
30 seconds, please. Thank you.
Yeah. The pre-distribution approach requires endowing everything with a capital stake and the security to hold on to it. So what type of projects could reflect this normative vision, this idea of pre-distribution? We discussed 4 possible projects. One is focusing on fundamental assets such as housing, so housing cooperatives and land trusts. Another project would focus on access to cultural property, which is also a central aspect of character and flourishing. A third possible project that was floated around is a project that would focus on takings, on expropriation, seen both as protection of private property, but also protection of commons property. There's a project on fixtures that was started last year, and we'll hear more about it soon. So these are the projects that are, we are discussing, we have on the table, and we'll see how things go. Thanks.
Franz Vero for the third group.
Thank you. So let me briefly report on what we've done. We had 2 things going on. We had to assess where we were in 2 ongoing projects, the project on causation and the project on products liability. Both groups met and adjusted their needs. I want to mention just one thing, which is that Markus Pilgerstorfer He's so British that I cannot get used to his German name, and so I massacre his German name, which actually is Austrian, I just learned. But Marcus joined the two editors of the Product Liability Project, namely Professor Joseph Page and Monica Josen. He's going to be serving in a editorial capacity, and we're very delighted to have him because we obviously needed some help. I think the project is looking good. As far as I remember the timetable, it's going to be a project that should see the end of all the work by the end of next year. The other project we discussed was the causation project, and I saw that a lot of work has already been done. The project is led by Marta Infantino and Eleni Servogianni, who both have done a tremendous work in collecting the reports, in assessing the merits and the shortcomings of the reports. They were able to give us a very precise picture of where we stand, and this seemed to me very encouraging. I want to mention also the fact that it seems to me that they've been working fast, which is unusual in the Common Core tradition. Usually projects take a long time. This one seems to have been mastered in very little time. I want to congratulate the two editors. We've also done something very new, or I think it's a case of first appearance. We've declared a project dead. We've declared that nothing has been done in the personal injury project, and we decided that we should state the fact that it is not going anywhere. Maybe that statement may have some therapeutic value. Maybe we'll be able to resuscitate the project because we've declared it dead, but we thought that to keep on hoping that it would come would serve no purpose. Another thing that we've done, and that was before we separated into separate groups, we've discussed future projects, and actually, as we always say, we had a very fruitful discussion. We discussed the possibility to launch new projects, and really we got to have a very good discussion. We ended up deciding that we would launch a project on liability for information, and we were delighted to see that Professor Richard Goldberg, would accept to be an editor for this project. Liability for information came from the idea of launching something on professional liability. We figured that professional liability was probably too ambitious, too broad, and so we ended up with this project. We also discussed in parallel the possibility to launch another project on the duty to protect people against others. This is the provisional title that we have at this point. We have found no editor, and the discussion will resume next time. I think this is all what I wanted to say. Thank you.
Thank you, Franz. Thank you, Franz. We have eventually come to the final part of this plenary session devoted to the future of Common Core research. The two keynote speakers are Matthias Reimann and Joe Page. They speak in the order, so the floor is to Matthias.
Thank you. Is this working? Well, incredibly, nobody has thanked and congratulated Ugo and Mauro for running the show for 20 years, so I want to do that. They have... I mean, it looks like these projects run themselves, but they don't. And if anybody's ever had a hand in any of these, he or she will have an understanding of how much time, resources, money, nerves, and frustration goes into this. And to sustain this project like this, on this magnitude, to build it up and then sustain it for 20 years, is a huge accomplishment. When Ugo and Mauro asked me to talk about the future of the Common Core. I was wondering whether they wanted some kind of prediction, some kind of prophecy, some kind of crystal ball, which of course I don't have. But I will instead talk about where you might want to take this project. So try to render some advice. But I have to make 3 preliminary remarks. The first one pertains to perspective. I'm in a peculiar position because I'm an insider turned outsider. I participated very actively for the initial years, and so when I looked at this project 10 years ago, on the 10th anniversary, I had pretty much an insider perspective. But I haven't been very involved in the last decade, so now it's more switched to an outsider perspective, and you see things differently from an outside, as you will notice in a moment. The second is that I asked Ugo specifically, do you want a laudatory speech praising the great things that the Common Core has done, or do you want a serious assessment from my point of view, or critique? And Ugo, as you know, opted for the latter, and I take him seriously, so that's what he will get. And last but not least, I will put my remarks in more certain terms than I feel them. I will speak quite forcefully for reasons of clarity and also to provoke a discussion, not because I don't think there's any doubt about what I say. And I will do this in 2 steps. I will first lay some foundations by giving a brief assessment from my now outside point of view of the current state of the Common Core. And then second, try to render some advice on where one might take this project, particularly how one want to tackle what I see as one of the project's truly great and threatening weaknesses. An assessment of the Common Core at 20 years, the current strength of weaknesses, sort of, is basically an exercise at looking at its track record. So I went back and asked myself, what were the project's initial ambitions when it got started in 1994, 1995? And what has become of these ambitions? Have they been fulfilled? The project, in my view, has been marked by 4 major ambitions, and I think it has succeeded in the first and second and failed in the third and fourth. The first and central ambition was, of course, as you all know, sort of objective and methodological and descriptive. The architects, Ugo and Mauro, wanted to combine the Schlesinger approach, the Common Core approach, with the Sacco legal formants approach in order to explore the extent to which European law has a common core or not. And that approach was to be purely descriptive rather than normative. And it was to be politically neutral in the sense of not advocating either unification or diversity. In this regard, the project has, in my view, been quite successful. It has managed to combine the approaches, Schlesinger and Sacco, very successfully. That has made for very hard and slow work, but this work has generated a series of high-quality comparative studies on specific topics, and these studies have shown where a common core exists and where it does not. And at least by and large, I think the project has also avoided the openly normative positions and has stayed out, by and large, of the raging political debates about private law unification. The second objective was maybe not expressly stated in the initial programmatic speeches, but at least in my mind, clearly implied, and that was to build a platform on which scholars, European private law scholars, and some from beyond Europe could meet and could cooperate to transcend a purely national perspective on private law. And that objective has been gigantically successful. I mean, the project has built in the early years and maintained over the years in a very extensive network of European and some other private law scholars. And remarkably, this network has been amazingly inclusive, highly diverse, even fairly democratic, and let's not forget that, most of the time actually fun to be engaged with. So it has Europeanized private law on the personal level, very heavily and successfully, and that may in the long run actually be more important than all the principles and rules that many other competitor projects are drafting. Third, over time, the research was to generate, as Ugo and Mauro put it in their initial opening remarks in 1995, quote, at least the main lines of one reliable geographical map of the law of Europe. When I looked at this a decade ago, I found that in this endeavor the project had failed. And the 10 years have since confirmed my view. I don't think the research has produced a map. The reasons for that is twofold. First, most of the studies focus on relatively narrow topics. And second, we just don't have enough of them to create information that allows us to see larger patterns. The 16 volumes that we have now constitute a very respectable library, but they analyze only a fraction of European contract, tort, and property law. Now, it's true that the map was never envisaged to be complete or comprehensive like a restatement, but it was meant to encompass, as Ugo and Mauro put it then, quote, the bulk of European private law. And I think we're far away from that level. Last but not least, the exploration of the Common Core was also meant to contribute to the development of European private law as a larger enterprise. Not by drafting principles or rules, quite to the contrary, but by providing assistance to those who do that. Now, of course, Ugo and Mauro, as the project architects, have always been very clear that they reject an instrumentalist view. The primary goal of the research was to produce knowledge and not to serve other ends. But they did see that knowledge as, and I quote again, a useful instrument for legal harmonization in the sense that it provides reliable data to be used in devising new common solutions that might prove workable in practice. And in particular, they said, quote, it should be very useful for and deserve more attention from official institutions that are charged to draft European legislation such as directives, regulations, etc., end quote. In this regard, I think the problem has by and large also failed. And I make this claim with some trepidation because I watch this now from some distance, but as far as I can see, the Common Core research has not had a significant impact on the development of European private law. In fact, it seems to me that those driving that process have by and large happily ignored the research results created in Trento and Torino. That's both true on the official or semi-official side in and from Brussels and in the many more private enterprises drafting principles or other projects. So after 20 years, we have a project producing comparative studies that produce highly detailed descriptions of the commonalities and differences in certain areas of European private law. We also have a project which has created an impressive and productive network of European and other private law scholars. At the same time, we have a project that has not produced a map and a project which has largely failed to influence in practice the process of European lawmaking. From that basis, if you now begin to look into the future, you ask yourself, how should the leaders of the project or how should the participants react to that situation? And of course, they should continue the successful side of the project. I mean, it's easy to agree on, right? I mean, they should pursue the two agendas that have been very successful, the exploration of the Common Core of specific areas of private law and the operation of a broad European academic network based on the principles of inclusion and diversity, and especially the involvement of junior scholars. There's, of course, room for improvement in this or that regard, and we can open that up in the discussion. It may not hurt to rethink some of the methodological features of the project. But by and large, I think in these regards, it is sort of, we should go by the old Anglo-American adage, if it ain't broke, don't fix it. With regard to the map building issue, I think this should just be abandoned. I looked at this 10 years ago and explained why I considered it a failure and why I think this cannot be fixed, that you cannot really build a map of European private law in any broader sense, given the method to which the project is committed. I don't want to belabor this again, and the problem may be moot by now, because it's my impression, at least from the outside now, that in fact the map building enterprise has de facto been abandoned. And perhaps all that needs to be done is to acknowledge that and officially declare it dead, and in that case, may it rest in peace. Now, the failure to render effective assistance to European lawmaking is an entirely different story. This is a failure that I think the leaders should try to overcome. They should seek avenues to introduce the Common Core research results into the process of making European law. They should do so for two reasons, and maybe in two ways. The two reasons for moving in that direction are the value of the research itself and the long-term well-being of the Common Core project. The more important reason is the value of the Common Core research itself, and more specifically, the unique contribution that the Common Core can make to the development of European private law. As we all know today, that development is in the hands of actors drafting rules and principles, ranging from quasi-legislation in the form of EU directives in Brussels to officially sanctioned projects like Common Frame of Reference or the Common European Sales Law, and all the way down to the numerous groups publishing principles of tort and contract and trust and family and other law. And whether this development is misguided or wholesome is a question we can safely leave aside here. But the fact is that all these projects ultimately rest on the belief of sometimes religious proportions that there is broad underlying unity in European private law, a unity which can be brought to light by academic research, which can then be perfected by eliminating some outlier positions, and which can even ultimately be legislated. To this pervasive ideology of uniformity, the Common Core research results are crucial antidotes. I mean, the published studies have demonstrated time and again that the extent of a Common Core varies widely among the label subjects studied, all the way from very substantial to actually quite marginal. And it has more broadly shown that pretty much all broad assumptions never survive close scrutiny. And the Common Core research thus constitutes an implicit but powerful critique of the mainstream's trust and generalities. The Common Core leaders should bring this to the tables of the European lawmaking process and inject a healthy dose of skepticism and realism into the ubiquitous and sometimes unreflected unification agendas. The other reason for ensuring more significant role of Common Core research in the European lawmaking processes is more mundane. It is the survival of the Common Core project itself. It's quite true, as Zweigert and Kurtz famously state in their introduction, that, quote, the primary goal of comparative law, as of all sciences, is knowledge. But it is also true that research projects consistently ignoring practical relevance ultimately threaten their own existence. Because at some point, outsiders stop paying attention. At some point, insiders want to see some practical relevance. And perhaps most importantly, at some point, funding institutions wonder why they should continue to support. Now, let me be clear. I'm the first to support basic research free from considerations of immediate practical relevance. That is why I actively participated in the Common Core project for 5 to 10 years, chairing the Torts group. I'm not suggesting that the Common Core research should be directed by the practical needs of European lawmaking at all. Quite to the contrary. In the current environment, it's perhaps more important than ever that the Common Core stick to its guns, because it's the only project that produces a fairly accurate, fairly descriptive, and fairly objective rendition of where European law in certain private law area really stands. But I am suggesting that the leaders of the project take the results that it's generated, so to speak, to the other side, so that these results are no longer completely ignored, but can become part of the general discussion. The question is then how to do that. And I'm not sure I have a final answer to that, but let me make 2 suggestions of how to bring the insights generated by the Common Core more actively into the European lawmaking processes. One way would be to actively seek a dialogue with other institutions and other groups. And that requires that the Common Core break out of the isolation into which it has, over the years, gradually maneuvered itself, or being maneuvered. From an outside point of view, that insulation is actually quite amazing. Now, this in turn requires a change of attitude. When I look at the Common Core project from the outside, I see sort of the tribal mentality that Günter Frankenberg described in a wonderful article on the 10th anniversary, which was published in one of the collections of essays on the Common Core. A tribal mentality that has sort of an air of superiority, as he then called it, the Trentinos, right? Marked by a sense of pride and of being different, an element of defiance of lawmaking agendas, and even a whiff of arrogance, sort of let them draft their principles and rules based on superficial or no comparative studies. We are better because we're doing serious comparative law. That may or may not be true. I think actually it is true, but it's not very helpful in any event. The Common Core project should stop feeling better and just settle for being different. The leadership should attempt to build bridges to the many institutions and groups actively making European private law, so that the Common Core's research can be introduced into their work. That's especially true for the critical message. That message is just too important to fall by the wayside. Now, make no mistake, this will not be easy. I have no illusions about this. The Common Core research is unlikely to be received with open arms by these other groups. And that's understandable. Their reluctance is due to the fact that looking at the messy reality of European private law questions their projects, and makes their work a lot harder. Right? But perhaps at least some of them, of the leaders of these groups, will be able to see that facing this messy reality will also make their work better, more grounded, more thoughtful, and more reliable, and more respectable and legitimate. The other way to bring Common Core research to a larger audience is to make its products more accessible. Currently, the barriers to access are very high. If you want to access the research results of the Common Core group, you have to obtain and possibly buy fat, expensive volumes that are available only in written form. Then you have to leaf through the table of contents to find a summary, and then you have to work through often very complex analyses of the findings of the volumes. Right? If you're in a position that you want to ignore these research results anyway, this is an open invitation to do so. Especially, if you're hostile to the results anyway. The Common Core project needs to lower the barriers of access to its results dramatically. That can be done. It's actually not that hard. The research results should be published in much briefer summaries that are much more easily digestible for outsiders, not for insiders. And most importantly, they should be put on the internet. I mean, in that regard, the Common Core research works in the Ice Age. There is almost nothing available on the website, publicly available as a free resource, that gives you any insights in what has actually been substantively produced. If that is done, the information can be distributed much more widely and cost-free, and therefore, hopefully, end up on the tables of those who should be influenced by them. So let me conclude. Despite its undeniable successes in many very important regards, the Common Core project is being largely ignored by the mainstream. Looking at it from the outside, it is striking and disconcerting that it has pretty generally been isolated, or it's being at least perceived as isolated. The new leadership should seek what they originally programmed to seek. And again, I quote from the opening remarks that Mauro and Ugo gave at the 1995 Trento meeting. Scholarly significance, impact, visibility, and appeal also outside of academic circles. This is particularly important today, since the Common Core now operates in an environment which is much less forgiving than the environment at its inception. Let's not forget that. A lot of water has passed under the bridge. When the Common Core was originated, I mean, Schlesinger was still alive. That's a long time ago. When the project was launched 20 years ago, the drive towards European private law was strong, and competition on the field was weak. Right? Enthusiasm for Europeanization and European private law was still fresh, almost unbridled, and amazingly vague. And the competition, in terms of competition, there was just very little. It's easy to forget today that in 1995, the Landau Principles were barely published, and that was pretty much the only thing out there, except for a smattering of directives, not nearly as much as we have today, and then a few periodicals that had just been launched on European private law. That was pretty much it. The game was wide open, and in such a field, it was easy to thrive and easy to matter. But today, we operate in a very different environment. Right? The last 2 decades have seen the growth of a large crowd competing on the field of European private law for resources and attention. The crowd now consists of a regulation-hungry bureaucracy in Brussels, a group of mostly German authors writing voluminous treatises on various aspects of European private law, Kurtz's contract law, Schlechtrim on unjust enrichment, von Bahr on delictsrecht, and so forth. An ever-growing cottage industry of unification projects, drafting legislative blueprints or principles, and then also the writers of a larger and growing group of European casebook in the Van Gerven series. Now, we even have had now, since 2011, a full-fledged European Law Institute. In such a crowded marketplace, it is easy for outsiders to perceive the Common Core, as Martin Shapiro put it in his remarks 10 years ago, and I quote, simply as one of the branch factories of the current European comparative law industry of mice production. In such a competitive environment, a project must not only be conscious of its added value, it must make that added value count and matter. And that cannot be done in splendid isolation. Thank you.
Thank you very much, Matthias. I hope we'll have time to discuss some of your ideas. Now it's turn to have Joe addressing the floor. Joe Page.
Thank you very much, Mauro. Matthias is going to be a very difficult act to follow, and I'll try to cut my remarks short because I know that there's going to be a very interesting discussion following. I just want to align myself with one point that he made, and that's the accessibility point. I think that's a very fundamental point. Our reporters on the Product Liability Project often look forward to coming to the annual meeting because that's the only time that they're going to be able to take a look at the published volumes that are spread out on a table. They have access to them, and we don't even have that this year. There's not even that table. So it's really basically inexcusable that we don't take advantage of modern technology to increase this accessibility. So getting back to what I wanted to say, it's with great humility that I sit before you today, burdened by the unmerited honor of delivering the final formal remarks at the 20th anniversary meeting of the Common Core of Private European Law Initiative. I think of the immortal lines of the Argentine tango singer Carlos Gardel in one of his great songs, 20 años no es nada, 20 years isn't nothing. After I agreed to speak, I learned that I would be listed on the program as a keynoter. For an American, that conjures up memories of keynote speeches at national political conventions, stem-winding orations that kick off these quadrennial events and set the tone for proceedings that end with nominations of presidential candidates. How thankful I was to learn that keynote speech-making is something else in Italy. And I would be at the microphone both briefly and terminally. But please don't tell my dean. He was super impressed when I told him I was going to be a keynoter, so don't let him. I've lost track of how many of these Common Core conclaves I've come to. I do recall that at the first one I attended, I overheard a conversation between two distinguished-looking Euro academics. One of them obviously was a Common Core veteran, and the other was a newcomer. And the newcomer said they were about to register, and the newcomer said to the veteran, well, what is a Common Core conference like? And the veteran said, well, a Common Core conference is like sex. And his friend said, well, what do you mean a common law conference is like sex? And his friend replied, well, it's like sex. When it's good, it's wonderful, and when it's bad, it's still pretty good. So with that as a standard, I'm actually not sure I can contribute much to what's already been said about the future prospects of the Common Core Initiative. Much has been written at past quinquennial commemorations by distinguished comparativists from both insider and outsider perspectives. And the spirit of self-criticism provides the theme for this concluding session. So what is it that an American academic who cannot even pretend to be a comparativist and who stands on the brink of retirement after a half a century of labor in the vineyard of torts can add that would be of use and interest here? Well, I've always been struck by two of the central concepts of the Common Law Project. First, the notion that its purpose is to create maps, and second, that in this juridical cartographic enterprise, the Common Core map maker should pay close heed to legal formats that help shape the so-called law on the ground that actually governs the resolution of disputes. I wonder if the evolution of the U.S. private law of torts during the past 50 years have taught, that I have taught, can tell us anything useful about maps and formats. When I first stepped into a classroom in 1964, tort law in the United States had undergone an exciting period of judicial reform. In the immediate post-war II era, the courts displayed bursts of creative energy, and they went about recognizing new duties, abolishing immunities, limiting defenses, fashioning expansive rules for measuring damages, and they even made up a fundamentally revolutionary doctrine of strict liability in tort in the field of product liability. I wondered what a map of U.S. tort law would have looked like before all of this happened. Would it have given any hints that anything like this was going to happen? Some of us, the young and the impatient, in 1964 and a few years thereafter, began to feel that tort law in the United States had become irrelevant to the to the vexing issues that were tearing at the country's fabric at that moment in the country's history. We thought that the purpose of tort law should be to comfort the afflicted and to afflict the comfortable. And we grumbled that tort law was contributing little, if anything, to the economic and to change the economic and social inequality and to halt abuses of power by corporations and other powerful institutions, both public and private. And our motto became "Torts is dead," which also led to a discussion of grammar. Should it be "torts is dead" or "torts are dead"? Well, in any event, how wrong we were about this. Tort law was still very much alive, and it was to a certain extent afflicting the comfortable. And what other reason was there to explain the reaction of the business community as it launched the so-called tort law reform movement? Corporate lobbyists went from state to state, convinced state legislatures to enact state statutes that eviscerated much of the common law that supposedly tilted in favor of the injured plaintiff. They set about doing a malpractice reform, medical malpractice reform, caps on damages. They abolished joint and several liability. And at the same time, too much of the academic community turned its attention skyward, and its energies were devoted toward developing sophisticated theories based on economics and other competing disciplines. The product liability law stabilized as a result of a restatement that restricted the rights of consumers to challenge product designs. And another thing that's happened over this period is that widespread disasters that might in the past have produced tort litigation instead inspired alternative compensation plans, such as occurred after the 9/11 attack and in the recent case of ignition failures in General Motors vehicles. So as I prepare to leave academia, I find things have come full circle, and we can once again proclaim torts is dead. I still read the so-called advance sheets, which contain reports of all the appellate divisions handed down in the United States, but interesting, novel, notable opinions are very few and far between. We see now cases involving whether people can get emotional damages for the loss of injury to animals, the animal rights people, lots of sort of strange fringe efforts. The landscape seems positively lunar. So back to our topic, how do you map all this? And is the map metaphor at all useful? Now it's worth pointing out that the restatements, which are, by the way, as you all know, an example of private lawmaking in the United States. There's no official status. But anyway, the restatements actually do map out the congruities and discongruities in the common law, say, of torts in the various states. So if you stop there, you could say that the restatements are also engaged in the map-making process. But then they, of course, take the next step in the sense that they decide on the basis of the weight of authority or the persuasiveness, which is the better view, and then they sanctify it by putting it in boldface print, the so-called black-letter law. But a map characterizes its subject at a specific point in time, and if legal rules evolve over time to respond to changing circumstances and needs, the map will need constant revision to reflect this. And as Matthias has pointed out, and he had pointed out earlier also in his review of the first 10 years of the Common Core project, the work of the Common Core covers only a small section of the Euro landscape, so truly significant progress would require human and financial resources far in excess of what the Common Core initiative can possibly muster. In that respect, one comparison would be between the Common Core endeavor and also the American Law Institute, which is operating in an environment with much less legal diversity and from a consensus binding American jurists, academics, and practitioners. Now, of course, the Common Law Project isn't a restatement. It doesn't purport to be. But as I mentioned, the process does involve first mapping the contours. Again, I would reiterate or endorse Matthias's argument about the rethinking, if not rejecting the map metaphor. Very briefly on legal formants, this, I guess you could call legal realism, comes to continental law, and it contains a very important insight. My sense is that the Common Core project has treated what Professor Sacco wrote about legal formants as holy writ, like, say, the Book of Mormon, and rather than instead of being an invitation to look at the real world of judicial decision-making and to explore exactly how civil law judges are influenced by non-doctrinal factors. And I know that some of the projects do that. Aurelia mentioned how the contract project is doing that. But to my knowledge, nobody is sort of going back to the original concept and then looking at as a whole at what the Common Core reports have to say about legal formants and sort of elaborating, taking Professor Sacco's insight to the next level, which I think would be a very important step. Finally, just a quick couple of points. I think after 20 years, there is a need for new ideas, new excitement, new blood, introspection, introspective examination of the purpose of the Common Core project. Common Core was exciting when it began. Perhaps it's time to generate new excitement. Something that just occurred to me listening to some of the talks at this conference, the emphasis and value that's placed on democratic decision-making, and if there is any restructuring of the common law process, one might give some serious thought to also incorporating some kind of democratic decision-making process into the Common Core project. That's my little radical suggestion here. But I know that you want to get to the discussion, so I'll just leave it at that. Thank you very much.
Thank you, Joe. Thank you, Matthias, again. Thank you, both of you, for these advices, for these insights, for these thoughts. Now the floor is open to any contribution from the floor. From Professor Dacronia is the first one. Aurelia.
Yes. I have participated to the Common Core project almost since the beginning. I have been a national reporter on 6 projects, and I think that, first of all, that means that I have a belief in the Common Core project, and I have to congratulate Ugo and Mauro and Professor Gambaro for all this opportunity of giving the possibilities to have all these interesting books published. But I would like to make criticism as well, and I share my opinion. I share the opinion of Professor Reimann. And I wanted to say that I think that if we have to abandon, of course there were no main lines of the map of European law, and but if we have to abandon C, we have also to abandon D, what you said about the development of the European private law. In order to see how the development of European private law is, you have first to have a map of what European private law is. And I think the reason why we didn't have this map, it's because the approach of Ugo and Mauro was very, according to my view, very democratic. That means that it gave the possibility to whoever wanted to present a project, just to present it, and if it was interested to be launched and to have a book leading to presentation of the specific subject. I think that if we wanted to have a map, and if we want still to have a map, this approach has to change, and we have to find the crucial issues of certain aspects, for example, of contract law, of property law, of tort law, what are crucial issues, and then to ask for editors to write about that, and not the other way around. Editors persons who want to become editors coming and proposing a kind of subject, which is interesting, of course, but it cannot give a coherence and a total picture of certain aspects and issues and main issues of what European law is in all countries and certain issues. This would be my thought if we still want to have a map on this. Otherwise, it's true that a common core doesn't exist. There is no common core exactly. But this is not bad to say that and to find what the majority and what the approach even of minority is that can be of help in order to have ideas in the future for the European Union and in general for our approach to topics and dogma. Thank you very much.
Thank you. Aurelia, then Professor Goldman.
Thank you. Thank you very much to all speakers for their fantastic contributions. Well, 20 years. I'm also a veteran. It's my 14th year of active participation in the Common Core. I fully agree with both with Matthias and with Joe on several aspects. First of all, with Joe, the project has always been very sexy. And I've seen it also as a coordinator first of a project within TORT and then as a project within the contract session. How easy is it to convince potential country reporters, also senior, very excellent scholars, to extract from their tight time schedule time to write these reports because they love the project, they love the idea, they see the originality, they see the added value, they see the sexy component. And also the result, or when they see the book finished, they say, wow, this is something which is never something similar has been produced. And Cambridge University Press, by the way, a couple of months ago, a representative of Cambridge came to Groningen, and they say, well, you know, Aurelia, the Common Core books sell very well. So they sell better than other comparative law books, than other books in the field of European private law. And they sell very well both inside and outside of Europe. A fundamental distinction has to be made between two types of comparative law: legislation-based comparative law and case law-based comparative law. The old traditional mainstream comparative law is legislation-based comparative law, legislation comparée. This project from the very beginning has been absolutely innovative insofar it focused very strongly on the law in action, on case law based comparative law. And this is the reason of the impossibility to make a circle fit into a square. The results of the Common Core project cannot be directly of use for drafters of model rules for European law, because the dimensions are completely different. The style, the culture, the legal culture of drafting model rules is another planet than the legal culture of really getting into the nitty-gritty of the results of courts, litigations, and balancing of different aspects, policy, rights, legal format, balancing of different legal formats in reaching a judicial decision. It's also it is quite difficult to put the results of a Common Core book in such a nutshell that it could be practically used for drafters of legislation. But you are completely right, Matthias. An effort should be made by the editors of the Common Core books, when the book is finished, to translate the results into a scientific article to be published in one of the leading journals of international distribution, to make the results more accessible to a broader public. And I know how extremely tiring the work at a Common Core volume is when the time is too limited, when the resources are too limited. By the way, it's a pro bono project. Nobody is getting paid for this tremendous amount of work. And this is good. This is good that it's on a voluntary basis, but this also explains sometimes that some editors or some authors simply stop working. They don't have any time any longer, or they feel overworked or whatever. But so a suggestion would be that the senior editors of the volumes which have been completed ask the help of more junior scholars to write together with them this scientific article, which kind of disseminates the results of the project to a broader audience. So this could be an idea for the future. Thank you.
I have to say I don't agree with that strategy. I think the idea here is really interesting. Having listened to everybody speak today, I just want to congratulate everybody for their superb speeches. What I found really interesting was Matthias. When he was speaking, actually, I thought there was a potential interaction between some of his ideas, which were particularly, and put it this way, some of his fears about the aims not being achieved, particularly aim number 4, which is, let's face it, impact, okay, which if you say that's a UK law academic, they will run from one side of the room to another, because basically a large proportion of UK research money will depend on impact at the next research assessment exercise results when they come out. So this whole issue of impact seems to have been very much well envisaged by the Common Core all those years ago. And I think it was astute of Matthias to indicate that these things are actually even more pertinent now than they were then. So my sense here is there's a potential connection between that plea and actually what Lawrence was talking about, which was the need for there to be a greater interaction between academia and the Commission and European institutions. I mean, Lawrence didn't actually spell out exactly how that was to be done. That's probably for another day. But he felt, that was the impression I got, that there was much more of that engagement from the United States and much less actually from the UK. Now, therefore, it suggests to me that there is a need for a strategy to ensure that the visions associated with the original Common Core visions, the 4 visions, are actually implemented. Now, it may well be that number 3 is declared dead in terms of the map. I'm not so sure yet as to whether you can declare it dead or whether it's merely resting. But as far as number 4 is concerned, I think this would be a total and an unmitigated failure and disaster for the Common Core to reject the 4th one. Because the 4th one is very important, and the idea of potential impact upon lawmaking is absolutely crucial. I do not subscribe to the view that a common law publication, a book, cannot have an executive summary. summarizing the main arguments associated with it. If you can't do that, actually, I think, and I don't want to be rude here, but we're actually pretty not very good quality academics who are not very good at communicating. We should be able to communicate executive summaries at the very minimum as to what these volumes say. And there should be no actual gainsay in relationship to that particular point. What is crucial, and I think, is investigation of how actually that impact on lawmaking can be achieved over the next few years, and the greater engagement with resulting in projects which have got to be more practically relevant. If the Common Core gets into the process of actually crawling up itself by things which are overly theoretical and potentially damaging actually to the longevity of the institution, then I think that's dangerous. That's not to detract from the fact that the Common Core should have that degree of independence. But what it needs to be doing is that there needs to be much more of a discourse going on between the very European institutions that we're talking about, the very lawmaking systems within the member states, and that could include the law commissions and various other lawmaking bodies within them, and much more of an interaction between these bodies. And that strategy needs to be worked on and is probably necessary in terms of leadership over the next few years. These are only the observations of a person who only joined it the other day, but is very keen to participate and to add to the new blood here.
Can I just ask a question? Because several people have mentioned the European Law Institute. How many people in the room are actually members of the European Law Institute? Okay. So the synergy is going on personal relationships rather than developing an institutional relationship. Is that the idea?
Yeah.
Mm.
The question should be phrased, how many people are engaged with the European Law Institute? Because one thing is membership, one thing is doing things.
The real question is, what is the European Law Institute doing? Which it is the real question.
Yeah.
Maybe a short comment exactly on this point.
Excuse me?
Exactly on the point of European Law Institute. The European Law Institute has been mentioned as potential competitor. I don't see it at all in this way. It's a potential way of networking and getting our very basic research into a much wider discussion. The European Law Institute, we don't know yet whether it will be a success, but if it will be, it's designed to build up on the very basic research, the political need, and build statements or instruments out of it. The statements are the short-term way the European Law Institute is functioning, but the instruments will be the interesting one. Where the European Law Institute will tackle topics and deal with it over a couple of years, setting up an expert commission, but this is always supplemented by an MCC, a Membership Consultancy Committee. And every member of the European Law Institute could then go with its knowledge in there and get its knowledge to produce better instruments. That would be a kind of restatement, the instrument. So get the knowledge of the Common Core project into the instruments. And I think this could be done by two ways. First of all, by personal involvement, of course. But secondly, I think it would be a good idea if the Common Core project would become an institutional observer of the European Law Institute. And by doing so, observing which instruments are launched, where we have knowledge, and ensuring that at least in the Membership Consultancy Committee, some of us are sent there and give their input. I think this would be a very easy way of getting more involvement and a better view of our project.
I think you're entirely right. Absolutely.
Thank you. Anyone else?
Thank you very much. I'm also a member of the European Law Institute, but a non-active member. And one of the reasons why I'm not active member is that I've seen that the legal culture of the work done at the European Law Institute is the traditional, old-fashioned legislation comparée. It's a traditional, or it's the mainstream objective of drafting model rules. Projects are awarded, projects are preferred in the selection of, well, the European Law Institute also issues calls for projects. And the projects which are ranked the highest are the projects which are the simplest, just drafting model rules on a certain area which has not been covered yet by legislative harmonization projects. And to me, this kind of methodology is too boring. I love this fantastic case law-based, meta-legal format-based, cryptotypes-based, innovative, innovative comparative law. And the European Law Institute, well, comparative law is to a certain extent, I would not say a bit disregarded, but it could be used better. In this regard, I completely agree with Tobias. We should try to put more common core and a more fundamental comparative law research into the European Law Institute. And perhaps I will try to better myself and go to the next sessions and try to change things. Thank you.
Thank you. Any other? Speaking of maps, we have been approached by a group led by law and economics guy who were interested in creating a sort of internet platform mapping the results in quite simplifying way, maybe oversimplifying way. But, so we are discussing the possibility how, because it's complicated, to gather all the results so far achieved and put them on a interactive map. But this is one of the ideas. Other ideas could be, yeah, you're right, disseminating or trying to better sell the products. But it's already very, as you said, and many said, it's been already very much time consuming, energy consuming, money consuming over these 20 years, this effort. That having new blood for going public, even though in the right directions, as you said, it's a big deal. It's a big deal. And in the near future, maybe we will think over the overall structure of the project in order to give sense and give actual direction to the advices we heard today.
I would like to add something.
Yeah, I know. Also because I was concerned by your silence. You've been too much silent this morning, and I was handing to you the concluding remarks and the thanks to everybody. Otherwise, it gets sick.
I just wanted to stay a little bit more in the conversation. So I think that there is agreement about that would be great to be better in disseminating the results, and I think that might go with the need to have new blood, because I'm a guy that I'm not on Facebook. I don't understand the things, and frankly, I'm not interested in that. I consider the impact factor the generation of the intellectual culture of our age. It's transforming law schools into shoe factories, and so I have extremely old-fashioned tastes from this point of view, but I agree that it would be very important to do that, and I think that can only come through transfusion of new blood. And 20 years of leadership of a project like this is longer than Gaddafi has been in power in Libya. so I totally agree, and this is also answers to your democracy quest. Of course, it's nice if we can, share a little more the network in the future. We will talk about that, and we are thinking about that for sure already. But so the fourth point of Matthias, of the two of the Matthias failures, the fourth one, I'm totally acknowledging it, and has been actually why that we were trying to do something, but for some reason we never were able to do that. I think it's a good idea that of asking to, whenever a volume is published of the Common Core, whoever edited it is so sick and tired of it that he doesn't want to think about it anymore. He said, great, it's done, And because that's part of the belaboring of this whole thing. And that means that, and also these volumes are damn difficult to review. Getting a book review of that is asking a guy, go ahead, enjoy, read this whole thing. It's kind of asking him to work a lot. And it's not a good, so the only people that could do a review are the people that are insiders, but academic style precludes someone who has just done a book to review himself. And therefore, I don't think that there were many reviews of the Common Core volumes for this kind of very structural reasons. Maybe what Aurelia was saying about, encouraging to publish executive summaries or something like that when right after a book is done would be a good idea. Another good idea would be maybe to ask to everyone who had done one in the past to provide us with 20,000 words of the main results in terms of Common Core of his books, and then doing a little publication of, of the 20 years anniversary with 16 or 16 executive summaries of the 16 books. That would be a good, little kind of present maybe for, we can do that, I guess. So these are all things that can be done. But I'm interested for a second to stay on the mapping metaphor, because this goes to the heart of the methodological issue. All the rest is completely okay. On this one, I would like to spend a few words, because you see the mapping metaphor, actually, we came out with that metaphor in '94. That was pretty damned an advanced vision at the time, because, at the time, remember, we were so much into positivism in comparative law, including in my own school of comparative law, that people were thinking about measurements, that we could actually measure analogies and differences on some sort of scale, buying into Cartesian quantitative visions of comparative law that emerged in some areas of comparative law and economic theater. And, and mapping is the metaphor that overcomes measurement. Mapping is about relationships. Mapping is about networks. Mapping has nothing to do with, so to say, objectify knowledge of Cartesian nature or scientific Galilean nature. Has to do with a level of knowledge that is qualitative. Qualitative knowledge requires mapping. And mapping is, something that we've been trying doing in that spirit. Then I agree totally with you, and this I also agree with you a lot, that mapping proved to be much more damn difficult. And, if we had covered the whole thing, then we would have mapped it. The point is that, the time that it takes and these kind of things makes it difficult. But I don't think that methodologically the nature of mapping is itself dead or wrong, except if we actually give a meaning to mapping that is, again, very much into the positivistic vision of objective knowledge. Seems to me that what I learned in these 20 years at least, staying there, sitting there, seeing these things happening, what I learned in these 20 years, for sure, is that when we were thinking about mapping, Mauro and Dow in '93, talking with Rudi Schlesinger, so we were talking about prehistory of the thing. The idea was that you could have a coherent map of European law. You remember? Like the metaphor of the traveler going around relying on some sort of thing that would guide him through European law. That was an idea of a coherent map that was itself an assumption that we kind of thought by believing that the factual approach, the Schlesinger-Cornell approach plus the Sacco addition could bring to some sort of objective knowledge, right? That we could describe some out there, which was the law in its complexity, and we could, kind of coherently describe it as a descriptive effort. And I learned in these 20 years with this experience that a lot of what we are doing, in fact, a lot of the results we get and a lot of the excitement from this comes from the kind of questions we ask. And the kind of questions we ask in the questionnaire determine quite a bit of the answers we get. Anthropologists have known that for a long time, that there is just very naive to believe that by a factual inquiry of some kind, you can get objective knowledge. What you're getting is a kind of getting close to what you want to learn, a kind of a mapping that is very much dependent on the kind of question we ask and the guy or woman who is answering that. Because there is an element of filtering, an element of capacity, an element of professionalism involved in all of this that I think we try to overcome by being democratic and open in the sense number two, not in the sense that, in the sense of being inclusive in the network. And this, it seems to me, that was something that it kind of changed over time, at least my sense of what we were doing. Now, I wonder whether we would have written the same, the 1995 paper, whether we were sitting down together, me and you, Mauro, now, to write it again, what kind of learning we would have taken from these 20 years in terms of questioning the fundamental positivistic vision that is there in both Schlesinger's and Sacco's visions, which is not making them any less useful than they are, but is making them part of an intellectual project that over time, seems to me, very gradually, we kind of moved a little bit away from. So the kind of questions we ask today, if we ask questions in a more conscious way, when Anna this morning was talking about the normative thing or whatever, the kind of question we ask, I think, must reflect the reality of European law that in 20 years have changed a lot. And that was said very well by Matthias this morning when he said, well, that was pretty much prehistory. Now, European law is a completely different thing, has gained a tremendous amount of actual power. It became much more sovereign than it ever been. We were working within the sovereignty of the state metaphor when we started 20 years ago. Your article about comparative law going away from the national borders, that to me was one of the really important articles in comparative. I'm not telling you because you're my friend, I really believe that. So to saying, well, this kind of state centrism that we have in comparative law, doesn't work anymore. It seems to me that that thing is kind of reflecting itself also in the Common Core as a natural transformation and evolution of what we are mapping now. So I don't think that the mapping metaphor was wrong. I think that what we have to come to grip with is that hopefully this enterprise will never end, because the world around us is not made by our reflection on it, but it's actually, we should reflect what is happening in the world around us. We should not become like economists that say, well, the laws of the economy doesn't work, is a problem of the world, is not a problem of my theory. No, it's a problem of the theory if the theory doesn't reflect the reality. So it seems to me that in the Common Core, this sort of bottom-up approach made the theory adapt to the reality quite well, exactly because the theory was not so strong to begin with. You know, we were never really positivistic in a kind of a self-conscious way. We were never really kind of normative in a self-conscious way because we were so skeptical theoretically in a way. It seems to me that we have been, that if we now observe the volumes from the beginning to now, we can see some kind of transformation in our own consciousness in carrying on this project. But if this is true, and I go back to if this is true, this requires, in a way, even more of a sense of the subjective nature of our inquiry and how the inquiry reflects a generation, an historical period, a development of European private law as a complex artifact around us. And it seems to me that the next step, the next 20 years, will be able to reflect these transformations and this different methodological sensitivity exactly by, opening up in terms of the so-called leadership. There was never real leadership here. There was just hard work in finding some money to fund a meeting and some work that Mauro mostly took care of, and kind of trying to tame Cambridge University Press absurd requirements on us. It was pretty much that. I never thought that there was a leadership or there was an agenda of some kind. There was just a kind of a rudimentary platform for people to kind of get together and see what happens. That was pretty much what ended up being. So this can happen to me in the future if, really we kind of get not a new leadership, but new energy and a new culture in the kind of people that are carrying on the everyday work. Okay, so said that, I guess we have to thank everybody. I think that we have a significant. We had I think a good meeting with the usual. I don't know whether it was good sex or anyway. okay sex. I would say I had better, but that sometimes. But I think it was a very interesting meeting. I thank, as usual, the IUC staff and everybody who made this together this possible. It's not clear to me who was the funder this year, but anyway, we'll thank the usual funders that are written in the paper. And as far as we are concerned, let's. I think that Maura now will write you something in the next month or so to decide what to do. There are some issues about November as a good date. It's becoming a little kind of sad. November is always raining. Maybe we should go back to summer. I don't know. I mean, these are all things that should be taken in some reflection. As usual, we would love and welcome feedbacks by emails or whatever like that. And again, thanks a lot. And I think there is still some food or something to some lunch. And see you next time. Thank you so much.